want to welcome everybody here. Thank you so much for coming so early in the morning. And I think everybody here knows me, but I am Lisa with Recruiting for Growth. And Theresa, I really, really want to thank you. And I know when we originally talked about this, it was months ago, and you did some preparation for it. And I really, really appreciate it, your being here. So I'll let you take it away.
Okay. For those of you who don't know me, my name is Theresa Phelps. I am a labor and employment attorney with Rosenblum Goldenhersh in Clayton. I've been working with businesses and employers for almost 20 years now in the labor and employment realm and in HR in particular. So I work with employers on putting together policies and just dealing with HR issues, including what we're going to talk about today, which is medical marijuana. I am not an expert in medical marijuana, but I have had some interactions in the field and dealt with this on the employer side. And so I'm going to tell you what I know. And if it's something that I don't know, if there are questions at the end, I'll just tell you I don't know, and I'll try to help you find the answer to that. So let's just go ahead and plow forward. As most of you probably know, medical marijuana was established in the state of Missouri in 2018 by a constitutional amendment, and it is currently a program that is administered by the Missouri Department of Health and Senior Services. They've created a separate division within DHS to administer the program. And the application process for it, relatively simple. You have to be a citizen of Missouri in order to apply. You have to have a certification from a Missouri physician that you have a qualifying condition. And the term qualifying condition is pretty broad. Lots of things, lots of conditions would fall within that categorization. And so I'm going to say it's not all that difficult in order to get a medical marijuana card in the state of Missouri. And so what I want to do is I'm going to share my screen with you because I'm a visual learner and I like to see things so you're not just looking straight at me, and you'll kind of see where I'm going with this. So let's do this. Okay. Okay, so that's the background of medical marijuana in the state of Missouri. So what's the problem for employers? There's currently a problem in that there is a state and federal law conflict on this issue. Marijuana is still illegal under federal law. It's classified as a Schedule I drug. And so while it's technically legal for medical purposes in the state of Missouri, it is technically illegal under federal law. And while there's not a lot of enforcement at the federal level for people who have medical conditions and are using medical marijuana in accordance with their state law, at any given moment, somebody in the federal government or in the federal agencies could decide that they want to enforce the fact that marijuana is illegal under federal law. And so you have this conflict between state and federal law. Now, that being said, all of this could change in the coming days if marijuana is declassified at the federal level, which it is currently being discussed. There's a push in Congress to declassify marijuana as a prohibited drug, as a controlled substance. And if that happens, most of what I'm going to tell you in the next 20 minutes could go right out the window. So I'm going to tell you where we stand now and kind of where things may be going in the future if we do see that declassification down the road. I also want to talk just really briefly about CBD. CBD is a big thing right now. Everyone's talking about it. You can drive down the street, you can see CBD shops. There are CBD products in stores. You can order them online. CBD is semi-related to marijuana. So CBD can be made from marijuana, which is illegal under federal law, or it can be made from the hemp plant, which is not illegal. Hemp is specifically excluded from the controlled substances. So it depends on what form of CBD somebody wants to get or is using. Pure CBD products do not contain THC. THC is the active ingredient in marijuana. So pure CBD products don't have that in there. And so pure CBD products would not show up in an employer drug test. If you're testing your employees, they're taking CBD product and it's a pure product, it would not show up in a drug test. That being said, There is only one manufacturer of CBD that is currently regulated by the FDA. And so that is the only product that is verified, that is 100% verified as pure, meaning it wouldn't show up in a drug test. And that's the Epidiolex product. Every other CBD product, even if the label says that it's 100% pure and it does not contain THC, can still contain THC, trace amounts of it, and that those trace amounts can still show up in a drug test. So as an employer, you may have an employee who fails a drug test and that employee has only taken a CBD product. Keep that in mind as you're administering your anti-drug policies in your workplace. So it is possible for your employees to test positive with just CBD product. So what are the risks for an employer with employees' medical marijuana use? There's a couple different things that are a risk to the employer. First of all, you've got the obvious, you've got possible employee impairment. So you have an employee who's using medical marijuana. They may come to work or be performing their work while they are impaired from that medical marijuana use. Impairment also raises the risk of injuries to the employee who is using the medical marijuana, and also to others around that employee. And when you have a risk of injury, you also have a risk of workers' comp claims. They go hand in hand. These are things that could arise from an employee's use of medical marijuana. Now, another risk that a lot of employers don't recognize and don't realize until they get in the situation of having an employee using medical marijuana is that most employers have drug-free workplace policies, and they should. If you don't, as an employer, you need to have one of those. But your drug-free workplace policy typically says no one can come to work impaired, no one can use illegal substances, and you reserve the right to test people, have drug testing. And so how do you enforce that drug-free workplace policy if you're allowing medical marijuana use, even if that use is on the side on off hours? That's still going to show up in a drug test. And so you've got a complication with how do you enforce that policy? And again, remember, marijuana is still illegal at the federal level. So what can employers do? A lot of employers think that because medical marijuana is legal in the state of Missouri, that they have to allow their employees to use it. And that's simply not the case. So just because an employee has an authorization to use medical marijuana does not mean that employers must actually allow the use. You as employers are allowed to enforce your drug-free workplace policies and prohibit the use of medical marijuana among your employees. So you have that right, you have that ability. We need to talk a little bit about on duty versus off duty, because I think the rules are a little bit different. So on duty time, an employee at work, an employee in an employer vehicle, an employee on company business, anytime that employee is on your time, is on the clock, an employer should absolutely prohibit an employee from using medical marijuana. So they come, clock in, they should not be allowed to use medical marijuana while they're on the clock, or while they're operating your company vehicle, or while they're doing your business, because they are within what we call the course and scope of employment. And if something happens during that time when they're in the course and scope of your employment, you can be on the hook as an employer. So on duty time, absolutely prohibited from using it. The harder question is, what do you do with the off duty time? So you have an employee who uses medical marijuana in the evening to go to sleep, or while he's at home, or over the weekend. What do you do with that? Because it's his time, and as employers, we don't like to tell employees what they can and can't do on their off time or while they're at home. Now, technically, you do have some right to do that as an employer, because some of that off-duty activity can spill over into the workplace when they come back. Currently, Missouri law provides that employees cannot sue employers for taking actions against the employee who used medical marijuana. And this includes use of medical marijuana on off-duty time. So as the employer, you still have the ability to say, I don't want you using medical marijuana even in your off hours, because it may come back, it may affect your work performance at work. I don't know how to tell if you're impaired, even if you've used it at home. All of these risks that there are to employers, you have the ability to say, we're not going to allow it. We're just not going to have it among our employees. And they can't sue you for that, which is kind of nice because it gives you the flexibility and freedom to decide how you want to treat the situation. Some of you who deal in the HR realm may be saying, well, wait a minute, don't we have a duty as an employer to make reasonable accommodations for employee medical conditions, employee disabilities? You do not have a duty to make an accommodation for the use of medical marijuana. It's kind of a little carve out, a sliver from that general rule that HR professionals are used to enforcing. The ADA, the Americans with Disabilities Act, and the Missouri Human Rights Act, which is the state equivalent, requires employers to provide reasonable accommodations for employees' disabilities. However, you do not have a duty to accommodate medical marijuana use. And the reason for this is because currently marijuana is still illegal at the federal level. So requiring an employer to allow medical marijuana use would be requiring an employer to essentially violate the law, condone violations of the law. Again, that could change in the future if we see marijuana declassified as a Schedule 1 controlled substance. So you have a duty to accommodate the condition. So let's say somebody takes medical marijuana for chronic pain. You may have a duty to see if there is something else that you can do to help the employee perform his duty even with that pain. But you do not have to allow medical marijuana use as that accommodation. Your accommodation may be you assist with lifting, or you allow the employee to take breaks so that they're not sitting at their desk for such a long time. But you do not have to allow the employee to use medical marijuana as the accommodation, and they can't. The employee can't insist that that's what you do. Another thing to remember is that just because somebody has what we call a qualifying condition for purposes of medical marijuana does not mean that they have a disability for purposes of the ADA or the Missouri Human Rights Act. Those are two different standards. And in the law, you have to look at the standard of the act that you're talking about. So there's a difference between those, and you've got to keep that in mind when you're talking about reasonable accommodations. So you have an employee that comes to you and says, I'm using or I want to use medical marijuana. How do you handle that as an employer? We have two choices. The first choice is you can prohibit the medical marijuana use under your drug-free work policy. You can just say, not doing it. We're not allowing employees to use medical marijuana. And you would treat any violations of your drug-free work policy, your positive drug test results, in accordance with your policy. Whatever your policy says, that's what you're going to do. It's very, very, very important, and I cannot stress this enough, for you to follow your policy. If you have a policy and you're going to prohibit the use, follow the policy. The policy says a drug test results in X consequence, impose the consequence. Keeping with your policy, following your policy will keep you out of trouble. It will keep you out of court. Your policy is in place for a reason. And while you do sometimes make some exceptions to the policy, the general rule should be follow the policy. That's why it's there. So that's choice number one. Choice number two would be to assess the specific situation, the specific employee involved, the specific situation, and then determine if medical marijuana use can be accommodated. So it's going to be a fact-specific determination, and you're going to work with that employee and try to figure out whether you can make things work. Right now, as an employer's attorney, I think that the best practice is to prohibit marijuana use, medical or otherwise, altogether, and strictly enforce your drug-free work policies. That is the safest course of action, given the risks to employers, and it leads to predictability. So you as the employer know how you're going to handle it because you have a policy in place, you have procedures. The employees know how you're going to handle the situation because you have a policy in place and you enforce the policy. Everybody is on the same page and knows what's going to happen if an employee comes in and says, I want to use medical marijuana, or tests positive and says, wait, I'm using medical marijuana. It also eliminates the risks in the workplace, the risks of impairment, the risks of injuries, the risks of workers' comp claims. That's the safest course of action. However, I understand and recognize that the law is changing, And that some employers are getting ahead of, they want to get ahead of the curve and, be current. What's going on in the workplace? What's going on in the industry? What's going on in the world? And so if that's you, if you decide that you do want to consider allowing your employees to use medical marijuana, there are some safeguards that you should put into place and you should think about in connection with that individual assessment. So first, you must assess the situation and come up with an individual plan. So you're going to sit down with your employee. You're going to discuss what he's doing, why he's taking the medical marijuana, and figure out, what are you going to do? What are the rules? What are the guidelines for this particular use? And in doing that, you want to make sure that you create boundaries. Boundaries might be an ugly word, but boundaries keep us all safe and keep us all on the same page. Everybody's got clear expectations of what's going to happen. So those boundaries need to address, no use, no medical marijuana use on company premises, no medical marijuana use on company time, in a company vehicle, when you're at work. You can't do that. Or even no medical marijuana use within so many hours of an employee's start time. If you want to make sure that it's not impairing the employee when they come to work, you can say, I don't want you using it within 3 hours, 4 hours of your start time, something like that. Create those boundaries with your employee so that they know what they can and can't do. I would also talk with the employee about what dosage is acceptable. So, what are you using currently and how much and how often are you using it? You should ask the employee for confirmation of the medical condition. What's your condition? Show me your doctor's certification that says you have this condition and that suggests that medical marijuana use will help you. You're allowed to ask these questions because this is part of the reasonable accommodation process. You also should just talk through those situations, so that you come up with an individualized plan and the boundaries. If you're able to reach an agreement with your employee as to what will and will not be allowed, document that agreement, put it down in writing. Here's what we came up with. Even if it's an email confirming, we discussed this situation, here's what we expect from you, here's what you can expect from us, put that documentation in writing. I would also suggest that you use periodic drug testing with that employee to keep the employee honest. Sometimes when you give an employee the green light to use medical marijuana, that employee may take that liberty and overuse the medical marijuana, abuse it, or even use it as an invitation to try other drugs, because they know if their drug test comes back and it's a positive drug test, they're going to say, wait, I'm just using medical marijuana. So if they're subject to periodic testing for you to make sure marijuana is the only thing in the employee's system, and that it's not at ridiculously high levels and it's not beyond the scope of what you guys talked about as far as dosage, they're going to be more honest in their use. The other thing you need to make sure you do is make sure that the employee who is going to be using the medical marijuana is not working in a position that involves heavy machinery or operation of vehicles or some other serious risk where the employee could physically injure himself or others at work. So if you've got someone who's using big, large piece of machinery, and if they're spaced out because they're on medical marijuana, they could cut their arm off or smash somebody else's arm. That's not a good situation. So you need to think about what position the employee is employed in and whether his or her medical marijuana use would be a significant or serious risk of injury to himself or others if they come to work and they're impaired. The other thing as the employer you need to do is make sure that you monitor the employee for signs of impairment at work. Employees may come to work impaired, either knowingly or unintentionally. They may not know that they're impaired. So you've got to make sure that your supervisors know the signs of impairment and are watching for that, especially with respect to someone who is using medical marijuana. And I guess the most important thing in this individual assessment is to have open lines of communication with the employee and trust. If this is a long-term employee that you've got a good rapport with, that you trust and that is honest and above board, you're going to be able to have this ongoing dialogue with them about, okay, is the medical marijuana affecting your work? How are you doing with it? Is it all, are things going well? Do we need to make any adjustments? Those open lines of communication will help you and the employee stay on the right path and keep everybody out of harm's way and out of trouble. If this is a new employee or an employee who isn't the most trustworthy, you've got to think about whether you want to give that person liberty to use medical marijuana if you can't trust them and you're not sure that they're going to give you full information and be open and honest with you. So how can you as an employer tell if an employee is impaired? The problem with marijuana is that a positive drug test showing the marijuana in the system doesn't necessarily show you the level of impairment. Unlike a breathalyzer with alcohol, where you can blow in the test and we know if you're over a certain percentage, a certain number, you're more than likely impaired. That kind of testing is not currently available for marijuana. And marijuana stays in your system much longer than alcohol does. So it's impossible to know an employee's level of impairment strictly from a positive drug test. Now, I do think that tests are in the works and are being developed to try to address this. And I think that that's going to be a game changer in this area once there is a test that can better pin down when an employee used the marijuana and what level of impairment that has in the employee's body. When that testing is available, it's going to be a lot easier for employers to open the door to the idea of medical marijuana use among their employees. But right now, the only thing you have is your eyes and your observation. And so your supervisors have got to watch out for and report signs of impairment. The signs of impairment are red or bloodshot eyes, a delayed reaction time, distorted sense of surroundings, poor coordination, feeling anxious or panicky or tired, although, those could be a sign of simply COVID these days, but of the stressors of COVID. But if you see somebody who's anxious and panicky or tired, combined with some other things like slow reaction time or poor coordination, that's a red flag to your supervisors. And that should be, wait a minute, this person may be impaired. And so if you have any of those signs, if you see any of those signs among your employees in the workplace, whether they're using marijuana or not, but particularly if you know they're using medical marijuana, red flags, you've got to do something about that. If you see those signs of impairment, you've got to send that employee home. If you witness those signs of impairment and you allow the employee to stay at work, performing work, and then something happens, there's an accident, the employee injures himself, herself, or somebody else on your site, you're going to be on the hook for some liability as the employer. And so it's very important your supervisors know those signs of impairment and recognize them, and that you act. You send the employee home if you see those signs. So what happens if medical marijuana, or if marijuana all of a sudden becomes a declassified drug? I think that is very likely in the new incoming administration. There has been a push in Congress, I think a bipartisan push actually, to declassify and legalize marijuana. And if that happens, I believe that we are going to see some law and some regulations develop that will impose a requirement upon employers to do that individualized assessment to see if a possible accommodation can be made for an employee's medical marijuana use. Right now, again, you don't have that obligation. You do not have to say, let's see if we can make this work. If marijuana becomes declassified, I think you're going to see that requirement, a new requirement, come into effect. And then just like regular ADA issues, the employer is going to have to say, okay, let's sit down, let's talk about this. Let's see if you can use your medical marijuana at home, off hours, and still come to work and do the duties for the employer. I would also just note that there is also a push in Missouri to legalize recreational marijuana. So right now we're just a medical marijuana state. I have heard rumblings that this year the legislature is going to talk about and be taking up some bills to legalize recreational marijuana, which will expand the scope of marijuana within the state. So we're going to see some new developments in the arena in the coming days. But right now, because medical marijuana is so new in the state, there isn't a lot of case law out there, and there isn't a lot of guidance as to how employers can and can't and should and shouldn't handle the situation. So right now, I'm telling employers best practices is to guard against the risks to the best that you can, and just be flexible and adjust as the landscape evolves and changes. 6 months from now, you might be rethinking your policies, you might be revising your policies, and so you just have to look at what the situation is now and move along when things develop and change. And I'm going to stop sharing my screen. And that is what I have for you.
A whole lot of information.
There is a lot.
And Greg, you're in Illinois.
Yes.
So
We have the recreational side legal as well, and it's a challenging area, that's for sure. The one question I have for you is, you mentioned when you see someone's impaired, send them home. What's the liability of someone sending somebody out in a car when you know they're impaired and you're pushing them off of your property into the public domain? Is there a liability that could come back saying, hey, you shouldn't have put them in the car and made them drive home? We debate about that liability.
Yes, and that's a good question. I don't think that as the employer, you would have the liability for sending an employee home because that employee can decide how they're getting home. But best practices would be to suggest that the employee take an Uber, call somebody to come pick him up and him or her up and take them home. So as the employer, your best practice would be, hey, look, I know you're using medical marijuana or you're impaired. We need to send you home. Can I call you somebody that can come pick you up? Can I call you an Uber? I know in Illinois, you may not have, in rural Illinois, you may not have Uber around or have that available, but I would use that first. If the employee insists on going home himself in his own car, then you have to let them. Obviously, you can't stop them. But I don't think that you have liability as the employer for sending them home from your workplace because you can't control what he or she does once they leave your work, your parking lot, your place of business.
Okay, thanks.
Mm-hmm.
anyone else have questions?
One quick question on the testing of someone in your office who is on medical marijuana. Can you charge them if you accommodate, can you bill them for the testing?
You can. And what I would say is I would keep that as part of your agreement, that when you're coming up with the individualized agreement as to allowing the medical marijuana use, you'd say you're going to be subject to periodic testing. You're responsible for the cost of that testing, so that if they want to move forward with it, that's on them. That's their obligation and burden. But documenting it keeps you out of hot water. If they come back and say, well, wait a minute, you should pay for this, you can say, no, we agreed. This was your responsibility.
Julie, this is Bruce. I assume then that you have to have a policy that people have to tell you that they've been diagnosed or that they have been prescribed medical marijuana, correct?
Yes. So it can come up to one of two ways. So either you can have a policy saying that employees who have been prescribed and are using medical marijuana must inform you, which your most drug policies say if somebody is using, or should say, if somebody is using a substance that could impair them or that could affect their work performance, they need to notify the employer. Whether that's medical marijuana or a pain medicine or something. So your policy should have that language in there. So an employee should tell you if they're using it and been prescribed it. But probably the more common way that it's going to come up is somebody's going to fail a drug test, and then they're going to come back and say, well, wait, I'm using medical marijuana. I have a card for it. And then you're going to have to decide, do you treat that as a policy violation because they didn't inform you ahead of time? Or do you want to take it from that situation and say, okay, now that I know you're using medical marijuana, here's how we need to treat that.
And then I also assume that this policy continues as of now, that on a pre-screened drug test, if they test positive for marijuana, it is perfectly free to not hire them at that point.
Yes, absolutely. And this is in Missouri. I don't know the specifics in Illinois because sometimes Illinois rules are a little bit different and more pro-employee than employer. But in Missouri, you absolutely could refuse to hire somebody because they're using medical marijuana at this time, because it is still an illegal drug under federal law.
Thank you.
Yep.
Someone asked, Heidi asked, how does the discovery or whatever not violate HIPAA?
The discovery of the fact
Or
that they're
talking
using
about
it.
the medical marijuana.
So HIPAA, interestingly enough, HIPAA does not apply to employers. HIPAA only applies to medical providers and people who maintain medical records. So billing, coding, people who maintain the medical records for the employer. As employers, we do voluntarily, I think, take on an obligation not to disclose under what we call HIPAA. There are privacy rights of employees, and we do keep medical information in a separate file from their personnel file, but HIPAA itself does not apply to an employer.
That's interesting.
Mm-hmm.
I had no idea.
I honestly, I only discovered this a few years ago when I was looking into the situation, and HIPAA, when you read the regulation as to who is a covered entity, an employer does not fit within those definitions, unless they're a healthcare provider
Sure.
as the
Yeah.
employer. So,
Yeah.
yeah.
Which also kind of opens another question. With medical marijuana, is that covered by your health care?
I don't
Or is
know.
that a whole nother topic?
Yeah, I don't know the answer to that. I assume, I don't know. I would think that it would be because it's, it's just like a pain medication. So someone's taking an opioid. However, because it's still a Schedule I drug, I'm not sure. I don't know the answer to that.
Wow, interesting. And probably could go on for days about.
Yeah. Oh, yeah.
Well, we are a little bit past the 8 o'clock hour. Does anybody have any additional questions that they want Theresa to cover before we hop off? Okay.
If anybody does have information, Lisa knows how to contact me, or I'll just give you my email address. It's just T Phelps, so first initial, last name, at G as in George, S as in Samuel, Z as in zebra.com.
Terrific. Thank you so much. Thanks everybody for coming. Theresa, thanks really for covering this.
Sure.
I truly
Sure.
appreciate it.
All right. Thanks, guys.
Greg, have a happy birthday.